So I know based on our conversations beforehand that you're very passionate about your work up on the Hill, and you enjoyed the work very much. I mean, as a staffer, pursuing these things, and the fact that it takes so long. I mean, what is your mindset that this is ridiculous? It takes too long, and is it frustrating, or do you become oriented to playing the long game and hoping that investigations will find the truth eventually and it'll play out? Just sort of your reflections on that.
Yeah, it certainly is. It certainly got frustrating,
Yeah.
and it's one of the reasons I'm involved with Good Government Now.
Mm-hmm.
Because they're advocating for more efficient subpoena enforcement procedures, the use of inherent contempt and other tools for Congress to be able to get information that it's seeking, and stand up for itself and use its own constitutional authority to get that information.
And if you were, not to interrupt, but if you were to apply sort of what Good Government Now is advocating for to this scenario, could you sort of speculate as to, how much time you would have saved and how much quicker you would have come to the conclusions? Or I know it's all sort of hypothetical, but
yeah, well, I mean, if the
what,
body,
what would be, well, how would it have changed the investigation in a positive way?
well, I mean, I'd like to. I think that if there were some actual real-world consequences, like a fine or like the withholding of an appropriation, or the withholding of nominations, more broadly with the support of the entire body, not just one senator, right? Mm-hmm. If you had that kind of concerted system where the institution's larger prerogatives were sort of enforced automatically by default, like, so for example, if the committee had a way to, certify that someone was not in compliance with the subpoena, and then there were automatic rules consequences that flowed from that. For example, an appropriation for that agency is not in order on the floor, right? Or
right.
It has to be reduced by X amount, or no nominations are in order on the Senate floor. If there were if the institution would build procedures and mechanisms that where it sort of the default is that it stands up for itself. Now, all these rules, the body can always waive any rule. So if there's a particular application of it that doesn't make sense, it can't enforce the rules on itself. But if the default were that sort of the entire institution stands behind the subpoena, and there were real-world consequences, maybe they would have gone through that process of pulling all the documents and looking at them much more quickly, and actually deciding and being required to make a decision, have incentives like losing money or losing a nomination or something that would create the incentive to actually do the work to respond to the informational request or to respond to the subpoena.
And ostensibly, probably, pushing things forward by a couple of years, maybe? Is that?
Yeah, I think so. I mean,
fair?
If there had been an incentive, they didn't want to defy the judge when the judge said, "Give me a privilege log."
Right.
They were happy to defy the committee when the committee said, "Please give us a privilege log." If the committee is in good faith saying, "Look, I understand there may be legitimate issues of privilege of various types. Explain to us what you're withholding. Give us the give it like in any other litigation.
Right.
Just treat us like like in any other professional
normal discovery process in the private sector.
Give us a discovery. Give us a privilege log. Describe each document withholding. Tell us why you're withholding it. Because once they go through that process, in this case, they determined, never mind. Yeah, here's 10,000 more documents that we don't even think are privileged. If they'd been incentivized to do that earlier, maybe you save several years and we get a lot more of that information sooner.